Hello friends, in my YouTube channel Advocate Amit Kumar Gupta. Today I am going to discuss the case of DWARKA Portfolio Private Limited versus Assistant Commissioner of Income Tax. This case is reported in 99 ITR Tribunal page number 620. The matter has been decided by Delhi ITAT and the date of the judgment is May 27, 2022. The facts of the case are a little bit unique and interesting. In this particular case, the company was strike off under the Companies Act. The demand of the company was confirmed by the CIT appeal and the department was pursuing for the tax recovery from the Assessee. The Assessee filed the appeal before the Honorable Delhi ITAT. The plea of the department was that since the company has been strike off, so the company does not have the legal right to fight its case in the further appellate authorities. For this, the Delhi ITAT said that there is section 248 and 250 of the Companies Act which says that after the strike off of the company from the Registrar of Companies, the company has the right to recover its dues from outsiders and the outsiders have the equal right to recover any dues which are towards the company. So the non-existence of the company or the strike off of the name of the company from the Registrar of Companies does not absolve the company from exercising its right for asking any money from any party to whom the money is due, or it does not also restrict the right of the other parties towards the company for exercising their legal right for their liability towards the company. So the Delhi ITAT said that if the case would have like this, that the department has lost the case before the CIT appeal, so the department will definitely go to the ITAT for the further appeal. So in that case also, can the department take the plea or the assessee can take the plea that the company is strike off, so the department cannot go into the appeal. So Delhi ITAT said that the department cannot play with two standards with at the same time. If the department has the right to go into the appeal against a non-existent company or a company which is strike off from the Registrar of Companies, so the assessee has the equal right for going into the appeal, whether it is ITAT, whether it is Honorable High Court or Honorable Supreme Court. So section 248 and 250 will save the assessee from the plea of the department that the company cannot go into the appeal into the ITAT in case the name of the company is being strike off from the Registrar of Companies. Friends, there is section 179 which says that if the demand of the company is not met by the company, then the department can move to the directors for the recovery of the tax, and the only remedy for the directors of the company in that case is that they have to prove that there is no fault or the tax dues are not because of their fault. So if the directors can prove this, only then they can save from the liability of the company, but it is very difficult to prove this thing. So if the company will not be allowed to go into the appeal to the ITAT, definitely the department will move to the directors and it will be injustice for the directors to pay for tax for the company. So in this particular case, the company cannot be restricted from going into the appeal against the order passed by the CIT appeal or the further appellate authorities. Friends, this case is very important. In all those cases where the assessee is a non-existent company and the company exercises its rights for the litigation for the income tax matters or any other matter into the further appellate authorities like ITAT or the High Court or the Supreme Court, simply because the name of the company is being strike off from the Registrar of Companies, it do not loses its right to become a litigant. The company is well within powers under section 248 and 250 of the Companies Act to go into the appeal and save it from the tax which is not due to the company, meaning thereby that the company can fight its case at up to any level, even if the name of the company is being stricken off from the register of companies. At the end of this video, once again I am repeating the name of the case. The name of the case is DWARKA Portfolio Private Limited versus the Assistant Commissioner of Income Tax. Thank you, friends.